Call Deputy Seán Kyne.
Gormagat Vascan Corla agus Cornfalter Riv and Rotgok Tov Shaw on Chakta Clare Daly. I'd like to welcome this legislation from Deputy Daly in relation to the Coroners Bill is certainly very welcome. We've often been told at other debates that our maternity services are the safest in the world, and clearly in the majority of cases they are, thankfully, but when deaths do occur, they're highlighted very often on our TVs and in court proceedings. And coming from Galway, we all, in the very recent past, know the tragic case of Savita Halapanavar. This seems a very sensible amendment. I welcome the government's support for it, but what could be a simple change to the existing Coroners Bill is being delayed, in my view, because of the necessity, and probably welcome necessity, to completely overhaul the entire coroner system, and that is regrettable because I think it seems very sensible. It seems something that should be done automatically, an automatic inquest being held in the cases of maternal deaths as outlined in Deputy Daly's bill. Can I just also speak, and I know that the complete overhaul of the coroner's system is being looked at, and what I've been led to believe is that there will be an increased emphasis on delivering leaner, better integrated and more customer-focused public services. Now, better and more customer-focused public services, I'd just like to speak on that in relation to Part 7 on page 32, which is the conduct of an inquest, or the notice of an inquest in the bill, which reads: a coroner shall, whether by post or such other means as he or she considers suitable, arrange for the notification of any or all of the following persons: A family member of the deceased; B, any witness whose presence is required; and C, any interested person of whom the coroner may be aware and who, in the opinion of the coroner, ought to be notified at least 14 days before an inquest is to be held, of the date, time, place and subject of the inquest. Now, I want to speak on this not in relation to the maternal deaths in particular, but a case again that to protect the privacy of the individuals involved, I won't name names, but I do want to highlight the situation that arose. And this is something I discussed previously with Minister Shatter and Minister Fitzgerald at an internal meeting. But a constituent who came to me, we'll call her Mary, who lost her mother. Her father had passed away previously. She had no siblings. Her mother died at home, alone in a town some miles away from Mary. And obviously, like any death, there was the grief and everything that goes with it. And there was an autopsy and pathology examinations. Now, what followed that was a very long period of waiting for the pathology results to come true. Now, I checked here with colleagues here that are doctors, and they said it normally shouldn't take more than a couple of months. This went on for months and months and months before pathology reports came back. I had gotten on to the coroner. Coroner was very helpful, said we're still waiting the pathology reports. I can't order an inquest until such time as they come back. The Mary herself was on to the coroner again, same story. And the coroner eventually rang Mary again to say we're still waiting the pathology reports. This is going on, coming up to a year after Mary's mother's death. What followed subsequently was that a friend of Mary happened to be uptown one day, and by chance she met with Mary's mother's carer, the carer that looked after Mary's mother before she died. And the carer expressed shock that Mary wasn't at the inquest into her mother's death. Mary wasn't at her mother's inquest because she hadn't been notified of it. She hadn't a clue that the inquest was going ahead, which was a year later after her death. Now, this again put into another period of shock and grieving and tears in relation to not being at an inquest, which she dearly wanted to be at, which she had things to say that I won't get into about care and mental services in particular. And it was unbelievable. Further to that, when she went looking for a copy of the coroner's report or the inquest report, she was charged for it, which she subsequently got overturned on appeal. But this was a further, annoyance and deeply upset that when she was at work one day, that an inquest into her own mother's death was taking place and she hadn't a clue about it. Now, when she contacted the coroner subsequently, the coroner said that he or she had notified a local guard in that town. Now, Mary didn't live in that town, and the guard didn't have a correct number, stated that he told Mary's uncle about it. Mary's uncle didn't tell Mary for reasons that they may not have been getting on, or perhaps he felt she was better placed not knowing or not attending the inquest on that day, to protect her or something like that. So I certainly think in any reform of the Coroners Bill and the Coroners system, that there needs to be a better system than that, because no way should an inquest into a death take place where the next of kin not know about it. If they don't go, that's their own business, but not even know that an inquest is taking place. I thought it was scandalous and caused grave upset to Mary following the death of her mother. So I think that in section 47 that there needs to be something specifically by registered post or whatever to ensure that the next of kin knows about the timing, the date and the place of an inquest. And again, when I highlighted this to Minister Shatter and Minister Fitzgerald, they both felt it should be looked at. So I want to put on the record that all, and particularly the people from the department who may be involved in a future bill, could take that on board.